A month before her 21st birthday, she was abducted from a Sutherland railway station car park by a group of homeless persons consisting of 4 males and 1 female. These persons were Bronson Blessington, Matthew Elliott, Stephen Shorty Jameson, Wayne Wilmot, and Carol Ann Arrow. Blessington had met Jameson and Elliott at a homeless shelter named The Station in the Sydney CBD earlier that day and had proposed, "Why don't we get a Sheila and rape her," a quote which became infamously known through Australian news media. The idea was agreed to. Arrow and Wilmot joined in. The victim, who was to be picked at random, became Balding. The gang of 5 had earlier approached another female, Christine Moberly, at the same car park, but she became concerned and quickly locked herself in her vehicle and drove home, where she reported to her partner the offenders talking with another female near a motor vehicle there. That person was Janine Balding. Police, upon being alerted to these incidents, immediately attended the Sutherland railway station car park itself, not realizing that the earlier encounters had happened in an overflow dirt car park on the opposite side of the rail line. This was the same car park from where Janine Balding had been abducted in the intervening period. She was driven in her vehicle to the side of the F4 freeway at Minchinbury in Sydney's west, and during that time was partially stripped of her clothing and raped at knife point by Blessington, Jameson, and Elliott. Arrow and Wilmot were in the car but did not rape her. On arrival at Minchinbury, she was again raped. She was then dragged from her vehicle, gagged with a scarf, hogtied, then lifted over a fence and carried into a paddock by Blessington, Jameson, and Elliott. She was then held down and drowned in a dam on the property. All 5 members of the group were arrested and charged with Balding's murder. After weeks of deliberations and testimonies, Elliott, Blessington, and Jameson were each given life sentences plus 25 years. Wilmot was sentenced to 7.5 years in jail, while Arrow was released on a good behavior bond, as the pair did not physically participate in the rape and murder. The sentencing of Blessington and Elliott became a topic of extreme controversy, because at the time they committed the murder and were sentenced, they were aged 14 and 16, respectively, becoming the youngest killers in Australia to be convicted and given the maximum sentence for murder. In sentencing the defendants, Justice Newman said, "To sentence people so young to a long term of imprisonment is of course a heavy task. However, the facts surrounding the commission of these crimes are so barbaric that I believe I have no alternative other than to impose upon young prisoners, even despite their age, a life sentence. So grave is the nature of this case that I recommend that none of the prisoners in the matter should ever be released." This trial was the first in Australian legal history where DNA evidence was tendered, leading to convictions based in part on that evidence. DNA samples were conveyed to a laboratory in the United Kingdom, which at the time was a world leader in DNA analysis, profiling and comparison. The 2 scientists from that laboratory who processed the DNA samples were brought to Australia to give evidence in relation to their analyses. Given its significance in being the first time DNA evidence was tendered in an Australian court, the presiding judge acceded to a request from the Crown prosecutor that police witnesses who were involved in the prosecution case be allowed to be in court prior to giving their evidence, to witness this history-making production of DNA evidence. Defense counsel did not object. In 2007, Elliott and Blessington were granted an additional appeal based on a staple missing from their files. Essentially, it was argued, because the Crown indictment was not stapled to the court file, it was not fixed to the court file as required by law, and the judgment was therefore not technically finalized. The High Court of Australia subsequently rejected this ground of appeal. In an article published in the Sydney Morning Herald, the crime was classified as a thrill killing.